The topic chosen for today discussion is the administrative law, in which we are going to see the topic reasons for the growth of administrative law. Administrative law வளர்ச்சிக்கான ரீசன்ஸ் காரணங்கள் என்னென்ன என்று பார்க்க இருக்கின்றோம். So we know pretty well that the government has three organs. The three organs of government are legislative, executive and judiciary. So the administrative law is mainly on the administration, that is the executive, that is the government has three organs, that is legislative, executive and judiciary. The executive, the law governing the administration, administrative law is law on administration. So what are the executives? There are two types of executives are there. One is called political executive and government executive. So we called this as dichotomy of politics. So the executive have to execute the work or policies derived by the legislature should be executed by the executive. That is the main important function of the executive. And they are also answerable to both legislature as well as judiciary. So they cannot they cannot overreach their capacity or power. So they are controlled. They have their own control. That is called the for that administrative law has come into existence and by leaps and bounds. And in 20th century it has developed like anything because of the laissez faire state or police state has been changed into welfare state. Now most of the state follow or adopt the system of welfare state. That is, the motto of the government is the welfare. They have to do lot of welfare activities, and for that they have to do lot of functions such as welfare to the people, education, social security, political security, so many securities and welfare activities the government have to undertake. Then now we will see it is not a new concept. It is already in the existence even during the period of Ashoka and Chandragupta Maurya. So from but the name has not been given as administrative law. The king is the person who ruled the country, and he is the person to maneuver the administrative law. So the main concept of administrative law by the king in those days is dharma. So dharma is the main concept of administrative law in those days. Now by leaps and bounds it has developed like anything, and we will see the we will see the definition of K.C. Davis. Administrative law is the law on administration, one thing, and then it is controlled by judicial that is review of administrative actions. All administrative actions are judicially reviewed or governed, judicially governed. So there are they cannot go beyond the rule, that is the concept of rule of law, and basing on the rule of law the constitution law has come. And now we will see this is according to K.C. Davis, and according to Jain and Jain, the state functions are money, and they have to control the administrative organs. So remedies available for when the rights are infringed, when the rights of the people are infringed, they can go for constitutional remedies according to Jain and Jain. Apart from that, being the welfare state, lot of social functions have to be done welfare activities to be carried out. For that, the welfare activities such as the Industrial Dispute Act, so many acts have also come. Industrial Dispute Act, and then Trade Union Act, Maternity Benefit Act, and ESI Act, Factories Act. So many acts have come because of the welfare activity which has to be done by the welfare state. So this is according to Jain and Jain. And three important functions are to be done by the administrative law, by the administrative authorities, as according to Jain and Jain. One is it is as spelled out composition and powers of administrative authorities. Who are all the administrative authorities? What is the composition of the administrative? And then fixes limits of the powers of authorities. So the administrative law fixes the powers of the administrative authorities. And then the third thing, procedure to be followed in exercising powers. And then the last one is, that is the judiciary and other means, controlling of administrative authorities by judiciary and other authorities. So the administration has to be controlled by judiciary whenever they infringe or whenever they go beyond their limit. And even if they are not accessing their authorities also, then they will be questioned by the authorities, that is judicial authorities. So the judicial review is there. That is according to Jain and Jain. Now we will see how the growth of administrative law has come. That is, it is according to it is governed by rule of law. Rule of law is the law is always governed by rule. That is, law is supreme. Nobody is above law, and the law should be is meant for all. This is the rule of law, important concept of rule of law. And we will see now, basing on rule of law, the constitutional law also framed, which has the preamble, the fundamental rights and fundamental duties, and also it also spelled the directive principle of the state policy, which is very, very important, wherein the principles of state in the direction of the welfare. All these things are spelled out in constitutional law, that is based on the rule of law. So first, in preamble itself, the state itself shall endeavor the social justice and economic, political activities, and also the liberty to people, equality to people, and also it will strive for the development of fraternity. These things are spelled out in the preamble. And in the fundamental rights, what are the fundamental rights to be offered to the citizens, and if it is infringed, it is subject to judicial remedies by means of writ, as per the Article 32 in Supreme Court, and as per Article 226, one can go to High Court for whenever the fundamental rights are infringed. Then now we will see there are how the growth, what is the need for the administrative law. So the defense and administrative should be, that is the main function of the state, because of the it has to do the police activity, police state, and also welfare activities, and also it has to do lot of the welfare functions also have to be done by the government, being the sovereign authority. Sovereign authority means the it need not be, it has its own power and other thing. and no external control can be exercised on the state. So that the welfare functions have to be done by the state. Because of that, to do all these things, the administrative law is required. And then next, second thing is judiciary is proved to be inadequate for each and everything. Going to the court and institution of suit is very difficult and time consuming, and cost is also exorbitant. To avoid all these things, the administrative law has come into existence. That is, speedy disposal is needed for some of the cases which requires immediate decision or immediate judgment. For such of those things, the administrative law is the best suited, such as the industrial tribunals, labor courts, where the speedy disposal of the case are taken place. Second thing, the legislature, they don't have time to elaborate the things, to they legislate for the people, and that is the special function of the legislature. But at the same time, they have no time. So they for important they lay important rules and procedures, but the detailed regulations, procedures are all they laid down by administrative authorities, and they will get the sanction and it will be presented to the legislature for sanction. So such a procedure is adopted for expertise the knowledge, and the rules can be tried. And another thing, once legislation is made, law is made, it cannot be tried and again it cannot be implemented, or again it cannot be modified, or if at all if it is modified or amended, it will take time. To avoid all those things, the administrative rules can be tried and modified. Then when found defective, if at all if that rule and other things found defective, the administrative action can be taken up immediately. And also delegation is also possible. All the activities need not be done by the legislature. The legislature power is given to the executive called delegation, and so delegation of these things are all possible in administrative law. Then administrative action, the administrative action is functional rather than theoretical. Then in ordinary court and other things, the formality they have to adopt. In administrative law, it may be sometimes informal, and evidence and other things for the court is not at all. Sometimes it may be found, if needed it can be, or otherwise need not in administrative law. Then administrative authority sometimes immediately take preventive actions. There is the possibility for taking preventive immediate action. Say for example, giving of license, rate fixing for each and everything, for say for example licensing and other thing. These things can be taken up by the administrative law. Then last one is the administrative action is effective, and whenever if it is if the functional things are defective, immediate action can be taken by the administrative authorities, such as suspension of the employees and revocation of the employees. These things are possible. And apart from that, the important thing is the destroying of, suppose, contaminated articles. Say for example, the mutton, once the mutton came from Rajasthan and they suspected it for dog, and then it was confirmed as sheep. But the thing is, it was not up to the mark, because the fridge facility was not that much, and it was found to be contaminated, and immediately they ordered for destruction of those the mutton. So such of the things are possible. Immediately they can order for the destruction of the contaminated articles. So these are all the important thing for the reasons for the growth of administrative law. So with this administrative law என்பது நடைமுறை சட்டம், அட்மினிஸ்ட்ரேஷன், நிர்வாக சட்டம். அந்த நிர்வாக சட்டத்திலே பல அனுகூலங்கள் இருப்பதால் அது இப்பொழுதிலிருந்து அல்ல, அசோகர் குப்த காலத்திலிருந்தே இருந்திருக்கிறது. ஆனால் அதற்கு பெயர் அட்மினிஸ்ட்ரேட்டிவ் லா என்று அப்போது கொடுக்கப்படவில்லை. அப்பொழுது கிங் தான் அட்மினிஸ்ட்ரேட்டிவ் லாவை நிர்வகித்து வந்தார். தர்மா என்பது மெயின் கான்செப்டாக இருந்தது. இப்போது எல்லா ஸ்டேட்டுகளும், இந்தியா இஸ் ஏ ஸ்டேட் ஃபார் எக்ஸாம்பிள், இட் ஹேஸ் டு டூ லாட் ஆஃப் வெல்ஃபேர் ஃபங்க்ஷன்ஸ். ஒரு ஸ்டேட் என்பது நிறைய நலத்திட்டங்களை செய்ய வேண்டிய கடமைக்கு ஆளாக்கப்பட்டிருப்பதால் அந்த உடனடியாக உடனுக்குடன் அதனை செய்தால் அது பலனளிக்கும், மக்களுக்கு பலனளிக்கும் என்ற வகையிலே இந்த அட்மினிஸ்ட்ரேட்டிவ் லா மிகச்சிறப்பாக இயங்கிறது. இது ஏன் வந்தது என்றால், பல வெல்ஃபேர் ஆக்டிவிட்டி செய்வதற்கு இந்த அட்மினிஸ்ட்ரேட்டிவ் லாவை வைத்து செய்கின்றார்கள். ஒரு லைசன்ஸ் கொடுப்பது அதெல்லாம் இமிடியட்டாக கொடுக்கலாம். ஒரு ப்ரிவென்டிவ் ஆக்ஷன் செய்வதற்கு உதவுகிறது. இவ்வாறாக பல வகைகளில் உதவுவதால் இந்த அட்மினிஸ்ட்ரேட்டிவ் லா என்பது மிகுந்த பலனளிக்கிறது. With this we conclude this video.